In April, the Canadian Wind Energy Association decided to apply for intervenor status in this case. This is allowed in civil proceedings. The parties seeking to intervene must make application to the court, and if successful, they may introduce evidence and cross-examine witnesses. In fact, they become party to the action. Now, the court has a choice. They can grant full intervenor status or deny it, or at the discretion of the court, the applicant may be granted what's called friend of the court status. So that's not quite a full intervenor. And that's what the court granted Canwea, friend of the court. It means that they may not introduce any new evidence and they may not cross-examine witnesses, but they may make a presentation at the time of the hearing. It's important to note that any submissions to the court, however, may only be based, and must be based solely on the evidence that is before the court and nothing else. They can't bring anything new to the table. We attended a hearing in front of Her Honor, Madam Justice Swinton, on May 4th, where Canwea's motion for leave to intervene was heard. The outcome was very much in our favor. That was the first hearing we were in. The best possible situation from our perspective, as I said, Canwea was not granted intervenor status, but friend of the court. Subsequent to that hearing, we submitted a supplementary affidavit from Dr. McMurtry. And this affidavit was based on a number of things that we heard in the hearing from the Attorney General. They immediately deferred the cross-examinations, which were a few days later. In July, we found ourselves in front of Madam Justice Swinton for a second time. This time to consider a government motion that, if successful, would have had very far-reaching effects. The motion asked the court to strike Dr. McMurtry's evidence in its entirety. It asked the court to declare that Dr. McMurtry was not qualified as an expert witness. Sorry, I chuckled too. They asked to strike all hearsay evidence, and finally to strike any evidence that became available after July 24th, 2009, which was the closing of the commentary period for the Green Energy Act regulations. As I reported in a recent update to Wind Concerns Ontario, the court found in our favor on all four issues. Extending the time allowance for evidence well beyond July 24th, in fact, right to September 30th, the day that the legislation took effect. We are very pleased with that decision as well. Having rejected the government's attempts to disqualify Dr. McMurtry and his affidavits, the court did decide, however, to delay the main hearing, recognizing that the Attorney General will now have to finally respond to the evidence we introduced. Evidence which the court refused to strike. So evidence which, to this point, the government has steadfastly ignored. As a result, the September 30th hearing date was vacated. At this point also, Canwea began to make noises about reapplying for full intervenor status. The reason they'd only be given friend of the court was the judge was quite worried that their involvement would make the September 30th hearing date too difficult to stick with. But now that it was canceled, they decided to reapply for full intervenor status. Justice Swinton met with the various parties on August 9th. She settled a number of issues, which really helped because it avoided the need for numerous hearings and potential considerable delays. Cross-examinations are now scheduled to take place the week of October 11th, as both sides will then require some time to review all evidence and prepare for the hearing. Taking the holiday season into account, the court has reset the main hearing date for January 24th and 25th, 2011. Now, it may seem to you that that's a long time and it's a big delay, but in legal terms, it's a really short time and it's a really small delay. And we're really, really, really happy. We have prevailed through every hearing so far, and the only reason that the delay had to take place was because the other guys are going to have to answer the charges we've laid, which they wanted to ignore. We remain aware of concerns that renewable energy approvals may be issued before that time for new developments. However, we believe that few, if any, will be issued before the hearing date. If any REAs are issued in the coming 5 months, there is now a right to appeal them. It is generally believed that the appeals process will take about 6 months, and the Environmental Appeal Tribunal, which hears those appeals, has the authority to halt construction while an appeal is ongoing. Any appeal should therefore extend well beyond the hearing date in January. Canwea may decide to reapply for full intervener status. If they do, we are poised to maintain the same position we have taken from the beginning by not opposing them. There appears to be much less appetite in the government camp to see Canwea admitted than there is in ours. In her decision pertaining to the original Canwea motion for leave to intervene, Madam Justice Swinton concluded, and I quote, "If the application succeeds," by the way, that's our application for judicial review. Okay, let me start again. Quote, "If the application succeeds, the members of Canwea will no longer have an opportunity to obtain regulatory approval for the construction of new wind energy projects in Ontario. And the development of utility-scale wind projects in Ontario will be effectively halted for an indeterminate period of time." Nothing less is our goal, and with the continued help and support of people from across this province, we will prevail. Thank you.